The International Criminal Court is now in session.
Good afternoon, everyone. Welcome to the quarterfinals. I'm presiding Judge Grace Harbour. I'll be presiding over the submissions today, and with me is my colleague, Judge Sémien. We have another judge who is experiencing some difficulty attending and may attend at a later time, so you may see him pop up once you've already begun your submissions. If we could start by hearing the introductions from the parties and how you plan to divide your time.
Good morning. Good afternoon, everyone. My name is Luisa Fernandes, and together with my colleague Sofia, we will act on behalf of the prosecution. Sofia will speak for the first 8 minutes on the issue of admissibility, and I will be speaking for the remaining 17 minutes on the issues of criminal responsibility and jurisdiction.
Good afternoon, Madam President, Your Honors, esteemed colleagues, may it please the court. My name is Solik Özgante, and I have the honor to represent Mr. Gravius in this matter. I will be speaking for the first 12 minutes, and my co-counsel, Ms. Elizabeth Kakabadze, will be speaking for remaining 13. We reserve 5 minutes for our rebuttal. Thank you.
Thank you very much. Then we will begin with the prosecution team whenever you're ready.
Ms. President, Your Honors, and may it please the court, my name is Sofia Rebecki. The prosecution submits 3 claims: the admissibility of the score on the case against Mr. Gravius, which I will be arguing, the jurisdiction of the court that files for the case, and last one, that Mr. Gravius is individually criminally responsible for the crime committed. This last two being presented by my co-counsel. I will proceed to our first claim, the admissibility of the present case. So firstly, following the principle of complementarity, I will clarify that no valid investigation regarding the present case is underway. The appeals chamber stated on the appeal of the Republic of Kenya against the decision of PTC that for such a case to be inadmissible under Article 17(1)(a) of the statute, the national investigation must cover the same individual and substantially the same conduct as alleged in the proceedings. The importance of the investigations covering these exact aspects is also sustained by the decision on the admissibility of Lubanga case. In the case at hand, the PTC-1 issued a warrant of arrest and subsequent surrender against Mr. Gravius for the crime of genocide, allegedly committed between March 2019 and September 2021. The charges in this sense, Your Honors, concern a specific crime, that is the crime of genocide, and against a singular person, who is Mr. Gravius, in a specific time frame. The investigations carried out by the military court in the Republic of Hanetu, in contrast to that, according to the case facts, paragraph 18, refer to crimes committed in several conflict regions throughout Hanetu since November 3, 2015. The defined period of time and territorial scope indicates that numerous conducts that happened in this period could be investigated, as well as several people acting throughout the state. In the Gaddafi case, it was established that, at a minimum, national authorities should prove that they are focused on the same course of conduct and series of events. Fact is still not proven by the defense in the present case. Noticing that, even if the acts investigated were the same, the legal characterization of them may differ, observing that it is a national investigation, while genocide is responsibility of the International Court. Therefore, based on the arguments raised before, it would not be appropriate to expect that the military court's investigations will cover exactly the same course of events as the one of the ICC. Proceeding, another important aspect to consider is the political instability of the Republic of Hanetu. According to the case facts, paragraph 6 and 7, in December 2015, the Republic suffered a military coup in which Mr. Gravius declared himself president. Less than 6 years later, after the first coup, in a national scenario surrounded by conflicts and instability, another military coup was applied, led by General Hitch, as mentioned in paragraph 17 of the case. The investigations initiated by the government of Haneto will only finish in August 2022, and there is no evidence that investigations are being carried out with pre-established requirements, being able to fulfill the investigations made by this court. Just because there are investigations ongoing, we can just assume that they are enough to supply with probative value, evidence, and sufficient degree of specificity the one of the ICC. On the contrary, the current scenario described only presumes that investigations will not be carried out as expected. But even if this court understands that the success of military coups, the changes in the distribution of power, and the general context in which the investigations are taking place do not mean a lack of capacity of the state to follow through with investigations, it should be noted that the investigations should not be considered the same as the one of the ICC. This fact by itself is sufficient to apply the principle of complementarity. Now, I will turn to the second part of the first claim, Your Honors. Article 17(1)(b) established that the case must be serious enough to justify the intervention by the ICC. As a way to objectify which case will be serious enough, this article must be interpreted in line with the principle of gravity. Thus, the quantitative and qualitative aspects of the crime must be analyzed, including criteria such as impact, nature, aggravating factors, etc. These aspects are also sustained and present in Garda and Goudet cases. It is important here to emphasize that these aspects will be clarified separately, but in the end, they must be considered together in view of the general context of persecution against a specific group, that is the Castilians, and the state of vulnerability that this persecution causes. Now proceeding, quantitatively speaking, more than 300 Castilians were killed and many more injured. But also, the means used to carry the crimes out is an important aspect to be analyzed along with the numbers presented. In Mr. Graves' campaign, as can be seen in paragraph 11A of the case, he claims that the security forces shall take all necessary measures. By itself, the use of armed forces such as the National Directorate of Security and the Special Presidential Guards to enter the homes of unarmed and unprepared civilians already indicates excessive use of power by these institutions. Furthermore, the abuse of power to justify the killings of Castilians was seen when SPG and NDS forced civilians to say they support CNF, proving that the objective of Mr. Graves wasn't end with the alleged terrorists, but just kill and persecute Castilians. Qualitatively, we must analyze the aggravating factors. In the rules of procedure and evidence in Rule 145(2)(b), certain factors must be considered, such as crimes in defenseless victims or with particular cruelty or discrimination. According to paragraph 14, there are reports of conducts that reveal the particular cruelty toward defenseless victims displayed in acts such as the arrest of women, forcing them to cook and offer sexual service in order to not be killed, and blocking families trying to flee Castilia's province, with no plausible justification for doing so. Those conducts show the position of the extreme vulnerability of the victims. Thus, the prosecution submits that the practice mentioned are not only of interest to the international community, but also met the required threshold of gravity in the scale, nature, manner, impact, dimensions, and aggravating factors. In that way, I conclude the prosecution's analysis regarding the admissibility of Mr. Graves in this court.
Mrs. President, Your Honors, good afternoon. May it please the court. My name is Luisa Fernandes, and on behalf of the prosecution, I will first prove that the case falls within the jurisdiction of the court, and secondly, that Mr. Graves is individually criminally responsible. So starting with jurisdiction, Your Honors, we prove that the territorial, temporal, and subject matter jurisdiction has been met. In relation to the first claim, Article 13b of the statute established that the UN Security Council may refer situations to the ICC prosecutor acting under Chapter 7 of the UN Charter. The Security Council may create territorial jurisdiction in the case of crimes committed on the territory of non-state parties, which is the case of the Republic of Hanato. The same situation has happened in this court before, Your Honors, in the al-Bashir case, when the situation in the region of Darfur in Sudan, a non-state party to the ICC, was referred to the court by the Security Council. In regards to temporal jurisdiction, according to paragraph 1 of the case facts, the UN Security Council referred to the prosecutor the situation in Hanato as of March 2019, so we have no issues regarding temporal jurisdiction as well. Your Honors, we would also like to argue that the case against Mr. Graves complies with the principle of legality, in line with Articles 22 and 23 of the ICC statute. This principle requires that a court may exercise jurisdiction only over an individual who could have reasonably expected to face prosecution under national or international law, as this court's jurisdiction decided in the Abd al-Rahman case. When applying the foreseeability test using the al-Rahman case, we can observe that the decision of the Rome Conference to maintain a 50-year-old text of the Genocide Convention, Article 2, in Article 6 of the ICC statute is evidence enough that it constitutes a codification of customary international norm, being highly predictable, further reinforcing that Mr. Graves could have reasonably expected to face prosecution for his acts. Your Honors, now I will argue that this court has subject matter jurisdiction over the present case. I will present to you 3 claims to be analyzed: that the Castilians are a protected group, the element of specific intent required by the crime of genocide is present, the elements of destruction in whole or in part, and underlying acts are present also. So, to first argue that the Castilians are a protected group, the determination of it shall be assessed on a case-by-case basis and by reference to the objective particulars of a given social or historical context, and also by the subjective perceptions of the perpetrators, as stated by the ICTR in Semanza case. The targeted group must have particular positive characteristics, such as nationality, ethnicity, race, or religion, according to the ICC jurisprudence in the al-Bashir case. In this case, the majority of the population of Hanato is of Hanu ethnicity. The language spoken by the Castilians is different from the one spoken by the Hanus, which is the main language. In Akayesu case, in the trial judgment, the ICTR decided that an ethnic group is generally defined as a group whose members share a common language or culture. Also, Your Honors, in 1889, the Castilians were forcibly resettled by a monarch due to cultural differences in one of the poorest provinces in the country at the time. Social differences between the Castilians and the Hanus are many, to the point of having been the cause of bloody conflicts in the country's history. Therefore, due to these facts, due to their hierarchical context, population, number, and ethnic differences in relation to the other predominant nationals, the Castilians are to be considered a protected group. So now, to our second claim, that the element of specific intent required by the crime of genocide is present. Following the jurisprudence of the ICTY in the Jelizic case, for it to be established, the perpetrator must first target a victim because of his membership in a certain protected group, which is clearly shown in the case facts paragraph 13, as Mr. X, a local resident of Luz in Luzari, was arrested and pressured to say he belonged to the CNF, and was only released when the NDS saw that he was of Hanu ethnicity, showing the specific targeting of Castilians. Also, there must be an aim to destroy such a group by committing the atrocities. Your Honors, consider the difficulty of acquiring direct evidence of the specific intent for genocide in the Kashayama and Rudizana case. The Trial Chamber 2 judgment, paragraph 93 in the ICTR, has held that the circumstantial evidence would provide sufficient evidence. The Chamber considered as evidence criteria such as the physical targeting of the group or their property, which happened in Luz and Luzari, according to the case facts paragraph 12, when the NDS and SPG entered multiple houses to arrest Castilians for affiliation with the CNF, without even having proof whether they were members of it, showing the systematic arrest of Castilians. With that, 200 Castilian men were shot dead, and only 2 were CNF members. And in case facts 14, we can see that the families trying to flee Castilla province were blocked, and by that, girls aged from 13 to 24 years old were arrested, and after that, they were raped without have any connection to the CNF, showing the intent to target all groups and not only the ones considered terrorists. Also, starting a narrative that described the Castilians as terrorists, according to case facts paragraph 8, Mr. Gravas ordered the Castilian local parliaments to cease all activities and allowed the isolation of Castilians from access to institutions of representation, such as the parliament. Also, the ICTR used the criterion of the use of derogatory language towards members of the group to analyze intent. Your Honors, in this case, Mr. Gravas called the Castilians and their supporters lying rats and said that he would eradicate the Castilian cancer from the map of the country, as you can see from paragraph 10 of the case facts. In assessing the genocidal intent, Your Honors, we kindly ask that the court takes into account the totality of evidence presented, rather than considering separately each act, as the appeal judgment of the ICTY did in the study case, in the paragraph 53. In this case, at hand, we conclude that the surrounding facts and circumstances of the case strongly indicate Mr. Gravas' specific intent to destroy the Castilians. So moving to our third claim, that the elements of destruction in whole or in part and underlying acts are present. Your Honors, the factual
Can I just ask one follow-up question? Excuse me, sorry. Can I just ask one follow-up question before you move on?
Of course, Your Honor.
On to the next argument. When you began this argument about subject matter jurisdiction, you referred to the specific intent of the perpetrators. And just now, I believe I heard you correctly, you referred to Mr. Gravas' specific intent. What is your submission? What is the prosecution's position on who has to have the specific intent? And if you could provide jurisprudence to support that.
Oh, of course. The specific intent must be of Mr. Gravas, as he was the commander-in-chief of the armed forces and security apparatuses of the Republic of Hainaut, and it is sufficient to prove his intent and not of his subordinates, because he was the one who commanded the troops, and he was the one in the charge of their commission of crimes. If I can move on to the third claim, Your Honor.
Please proceed. Thank you.
Excuse me.
Of course.
Excuse me. Yes, I have a question. Coming to admissibility and more specifically on the complementarity, as you raised this point. We all know that complementarity is a legal core principle of, in this case, since there is a military court that was which was established, you don't think that it's an expression, a proof of the willingness of a state to investigate on this case? At least you don't think that the pretrial chamber should consider this step forward by establishing this court? And I mean, how you make the balance between the investigation of the military court and the fact that the OTP want to pursue on this case? First. The second question, Gravius said that the country was facing terrorist act. You don't think that although the operation he ordered were only policing operation just to maintain the order, as if the country was attacked and it has commander and president in charge of defending the country? What delimitation do you make between simple policing operation and genocide acts?
Right, Your Honor. So first, on the question of admissibility, as my colleague stated, the case must adhere to the same conduct and same person test, and this is not the case here. So that's why we are not saying that the military court cannot investigate, but it's not the same the same person that is going to be investigated, since all persons in the acts were going to be investigated, I believe, by the military court. And also there is a political instability in the Republic of Hainaut. And by that, we believe that the ICC is the one who has the admissibility character is established here, because we can see a political stability in the country, and also that the same conduct test is not established. And also to the second question, Your Honor, this counterterrorism campaign is it was established to prosecute, to deal with the terrorists of CNF, but we can see, as I stated, that many people were arrested and 200 people were killed, only 2 of them being CNF members. So this campaign is just, it was just included and following Mr. Gravel's orders, but we can see that it constitutes a genocidal intent in the campaign, because the way they are conducting the researches and the way they are conducting the deaths are not of a legal policy by the state. If this answers the question, Your Honor, I will proceed now. So moving to our third claim, the elements of destruction in whole or in part and underlying acts are present. The factual context of the present case, especially concerning the case facts contained in paragraphs 12 to 15, can be subsumed with Article 6 of the statute, since 200 Castilian men were shot dead when they resisted arrest, and IHD reported that 86 male Castilians were shot in the head, covering the criterion of killing members of the group. Also, SPG officers kicking pregnant women in the stomach were also observed by a witness in Luz and Uzari, constituting the criterion of causing serious bodily or mental harm to them. Also, due to the forced closure by the police department of all local business, and due to the fact that all routes to Castilla were blocked, a severe famine occurred throughout Castilla, causing the death of women and children of Luz and Cecil. This blockade and the closing of business, which according to the case facts paragraph 4 were largely agricultural, caused the starvation of the Castilian, amounting to the criterion of deliberate inflicting conditions of life calculated to bring about its physical destruction. So, Your Honors, now that the prosecution has proved that the prerequisites of the configuration of genocide are fully met, we'll move on to address that there are reasonable grounds to believe that Mr. Graves is individually criminally responsible. Mr. Graves served as a military commander to the NDS and also as a non-military superior to the SPG and police department. It is important to mention that a head of state can at the same time be a military commander to the armed forces and also a civilian superior to the government or any other political body, which was confirmed in the ICTY Karadzic case. These relationships can be confirmed as Mr. Graves had the capacity to issue orders and to sign them, and as he did when he introduced the counterterrorism campaign, directing the NDS in coordination with the SPG operating under his direct command, and also to make sure that such orders were followed, which is the case since he obliged heads of all 3 security divisions to report personally to him and on a regular basis. All these indicators of effective control of a superior were mentioned in ICTY Selibich, Delalich, and Blastic cases, supporting the argument. So due to these facts and the hierarchical nature of their positions, he exercised the jure and de facto control of their security apparatuses of the Republic of Hainaut. So proceeding to the mental element of having actual knowledge, Your Honors, that is the same for military and non-military superiors, the suspect's knowledge must be obtained through direct or circumstantial evidence, which was defined in the trial chamber of the Bemba case. Also, it is held in the ICTY Blastic judgment that an individual command position per se is a significant indication that he knew about the crimes committed by his subordinates. Mr. Graves was the president and the commander-in-chief of the armed forces of Hainaut, supporting this position of the ICTY Blastic judgment. In addition, a superior must also know with substantial likelihood that his order will result in the commission of a crime, as it was sustained in the ICTY Static case. The orders of the counterterrorism campaign issued by Mr. Graves were given in an unstable situation and under the possibility of a severe internal disturbance, where reasonable grounds stand for the high risk of commission of crimes. Also, the actual knowledge regarding the commission of crimes in Luz and Lusari can be inferred from the interview of Mr. Bryan, mentioned in paragraph 12 of the case facts, when he said that the NDS and SPG were only following Mr. Graves' orders to prevent potential threats to the security of Hanu people and Hanatum Republic. Moreover, the IHRD reported that the crimes were being committed, and also images from the severe period of famine were displayed on social media, showing dead bodies of women and children on the streets of Luz and Sisu, as we can see in case facts paragraph 15. For these facts, it is clear that Mr. Graves had actual knowledge. So proceeding, Your Honors, to the duty to repress of the statute, as it was seen in the ICTY Cordic and Sarkis case, two distinctive duties are covered. First, the duty to stop ongoing crimes from continuing to be committed, and second, the duty to punish forces after the commission of crimes. For that, Mr. Graves should have taken all necessary and reasonable measures, which did not happen, since Mr. Graves neither took the measures to repress by punish his subordinates, nor did he submit the matters to a competent authority to further investigate or prosecute. When asked by reporters about the humanitarian catastrophe in Luz and Sisu, he mentioned that the situation was due to the fraying economic situation and that his government was trying to control it, as pointed out in case facts paragraph 16. He blamed the leaders of Castilla for corruption and called the decision of the Security Council a conspiracy against the national security of Hanatum. Moreover, Your Honors, it was sustained, if I can ask for another minute or half a minute just to conclude the argument. Your Honor.
Yes, please. Another minute is fine.
Thank you. So the failure of superior to fulfill his duties during and after the crimes can also have a casual impact on the commission of further crimes. It was Mr. Graves' dereliction of duty that consequently increased the risk of commission of crimes, as he did not counter their commission and blamed the Castilians for the humanitarian crisis in its entirety. Therefore, Mr. Graves failed to ensure that the offenders under his effective control were brought to justice. He took no measures to prevent or repress them. From Mr. Graves' interview with the international reporters on the humanitarian catastrophe on 16 October 2019 to his arrest in September 2021 by General Rich, Mr. Graves had 23 months to act. And despite having access to the reports of the IHRD and Resolution 2022 of the UN Security Council, he decided to overlook the situation. For all these reasons, Your Honors, brought before the court by me and my co-counsel, the prosecution hereby requests the court to declare that the case against Mr. Graves is admissible before the court, the case against Mr. Graves falls within the jurisdiction of the court, and that Mr. Graves is individually criminally responsible for the crime of genocide. Thank you, Your Honors.
Thank you. We'll now hear from the defense whenever you're ready.
Good afternoon again, Madam President. Your Honors, may it please the court. With your permission, the defense submits 3 claims. Firstly, the case is inadmissible since the national investigation is ongoing and the case fails to meet the gravity threshold. Secondly, the court does not have material jurisdiction over the case. And finally, Mr. Graves is not criminally responsible for the crime of genocide under Article 28 of the Rome Statute. May it please the court, before I start with our first submission, the defense would like to respond to the OTP submission and clarify the ambiguity surrounding the standard of proof. The defense is aware that when it comes to determination of admissibility of a case, a state that challenges the admissibility bears the burden of proof to show that the case is inadmissible, as the ICC deliberated in Gaddafi admissibility decision. Although pronouncements made in Gaddafi case was made in the context of an admissibility challenge lodged by a state, the ruling is still applicable to our case in the context since there is no reasons why the burden of proof for an individual bringing an admissibility challenge should be different from that of a state. However, the standard of proof is much lower for the defense and constitutes of showcasing evidence solely of a sufficient degree of specificity and probative value that demonstrates that the authorities are indeed investigating the case. However, when it comes to unwillingness and inability of the state to investigate, the burden shifts to the prosecution, which has not been addressed by the OTP, as Your Honors has noted. Bearing this in mind, the defense will now move to the first submission and demonstrate that the case is inadmissible pursuant to Article 17(1)(a), since the national investigation is ongoing and the Republic of Hanatun is not unwilling or unable to carry out said investigation genuinely. The courts
Can I just interrupt you before you move on? Just if you have any jurisprudence to support your submission that the standard of proof for an individual is lower than if it was a state's challenge, and also to support your submission that the unwillingness aspect entails a shift of burden back to the prosecution.
Yes, Your Honor, I will answer your question in two parts. First off, the standards at this stage of proceedings is substantial grounds to believe, since the stage we are currently on is a confirmation of charges under Article 61 of the Rome Statute. However, the OTP argued that standard of proof was a reasonable grounds to believe, which cannot be considered as admissible by this court. And the jurisprudence you have asked for is the Gaddafi case, where this very court deliberated that standard of proof for the admissibility when the burden of proof is shifted cannot be as high as, for example, reasonable grounds to believe, which once again is lower than the substantial grounds to believe the OTP is tasked to provide the evidence for. Then moving on to the second part, when it comes to unwillingness and inability of the state, the standard of proof is shifted once again for the prosecution, since it's in his merits to show that the state was not willing by the factors mentioned in Article 17(1), which is by shielding the person, by delaying the proceedings, or have impartial and not having impartial and independent judicial system, which once again was not addressed by the OTP, as Your Honor has noticed, and therefore was not challenged by this on this case by the prosecution. If I satisfy your interest, may I proceed? Yes, thank you. So the court's jurisdiction shall be complementary to national criminal jurisdictions, meaning that the ICC only conducts investigations where there is a clear case of failure to act by the state or states concerned. A case with a state will be rendered inadmissible as so far as the national investigation, prosecution, or trial covers the same person and substantially the same conduct as alleged before the court. And to respond to the OTP's allegations, there is no requirement for the national prosecutions to be identical or to cover exactly the same article to those of the ICC as elaborated in Gaddafi case. And in a case at hand, the authorities in Hanatun has taken a progressive, concrete investigative steps to ascertain whether the individual concerned was responsible for the conduct. On December 10, 2021, a military court was established to investigate crimes committed in conflict regions, including Casteria. And Your Honors, this undoubtedly entails investigating the legality of Mr. Gravius's conduct, considering his position as a head of the country. And moreover, Mr. Gravius was held in prison and was placed under house arrest, once again highlighting that authorities were willing to bring the perpetrators to justice. And since since nothing in the case indicates to the contrary, the defense submits that alleged crimes supposedly conducted by Mr. Gravius will be covered by the ongoing national investigation, which sufficiently mirrors the case investigated by the OTP. And Your Honors, once again, the defense would like to reiterate that the national investigation is covering the same case and the Republic of Hanatun is not unwilling or unable to carry out said investigations accordingly. And since impartiality and independence was not challenged by the OTP, the defense still would like to reiterate that we are aware of the fact that number of military officers have recommended Mr. Gravius's release. However, the statements made by public officials cannot be considered to be enough to taint the domestic process. What matters here, Your Honors, is whether these statements were made by the public officials dealing with the case. And in this regard, I would like to draw your attention to the clarification number 3, according to which the high-ranking military officers that have recommended the release of Mr. Gravius have no connection to military court, thus there is no evidence to support the idea that independence or impartiality of the military court has been tainted in any way. And Your Honors, other than absence of unwillingness, the Republic of Hanatun is not unable to carry out proceedings accordingly under Article 17(3) of the statute. And nothing in the present case supports the idea that judicial system in Hanatun has somewhat collapsed. Moreover, the state was able to obtain the accused and the necessary evidence and testimony, once again highlighting that instability that was indeed ongoing in the Republic of Hanatun before the new government took control has in no way has tainted the domestic process. Moreover, OTP relies heavily upon the reports of non-governmental organizations and press articles, which might be problematic as deliberated by this very court in Gbagbo case. NGO reports do not constitute a valid substitute for the type of evidence that is required to meet the evidentiary threshold for the confirmation of charges stage, which is substantial grounds to believe, and raises the questions such as why the prosecution was not able to obtain more trustworthy evidence through its own investigation under Article 54. Your Honors, with your permission, we would like to move to the gravity criteria and highlight that the alleged committed crime of genocide fails to meet gravity threshold as, firstly, the number of victims cannot justify further action by this court, and secondly, the scale, nature, and manner of commission renders the alleged crime inadmissible qualitative dimension of the gravity. The gravity requirement is firmly tied to the number of victims. And in this case, the number of Castilian people who have allegedly suffered harm is not comparable to international jurisprudence. ICTY found in Prestige case that over the course of 1 week, 7,000 to 8,000 Bosnian Muslim men were systematically murdered in mass. In contrast, the number of alleged victims in the present case is considerably lower, constituting solely 286 deaths. The total number of casualties renders the case at hand of marginal gravity. And regarding the quality criteria, the prosecution failed to establish that information available Mr. Gravius's conduct demonstrates the existence of severity or existence of the nature of the unlawful conduct, which would be in this regard should be considered the manner of commission and its cruelty, which was not substantially provided, the substantial evidence was not provided by the OTP. And to respond to the OTP submission regarding the social alarm caused in international community, the defense admits that the doctrine of social alarm was considered irrelevant, and this approach would politicize the ICC's actions, since just as crimes the world obsesses over might be insufficiently grave to warrant investigation, crimes the world ignores could be more than grave enough. Therefore, the social alarm test is not based on objective criteria and should not be regarded by this court as admissible while assessing the gravity threshold. Madam President, if I cannot be of further assistance to your honors on this matter, I would like to move to the defense's second submission. Should the court find the case of Mr. Gravius admissible, the defense admits that the ICC does not have material jurisdiction over the case. Our argument regarding the court's material jurisdiction rests on two pillars. Firstly, Castellians do not constitute a protected group, and secondly, Mr. Gravius did not possess requisite dolus specialis to destroy Castellians in whole or in part. Starting with the absence of existence of a protected group under Article 6, only 4 kinds of groups are protected for the purposes of ICC jurisdiction: a national, ethnical, racial, and religious group. The OTP tried to make a case that Castellians might be identified as ethnic group. Even in this regard, it is our submission that necessary evidentiary threshold has not been met, and it has not been clearly demonstrated that Castellians possess common language and culture or tribal links to their land. However, in this case, arguing about the potential ethnicity of Castellians would prove to be without merit, since the targeted group was polarical in nature. And, Your Honors, in this regard, we would like to draw your attention to clarification to case facts number 7, according to which SNF, against who was Mr. Gravius's counterterrorism campaign intended, included Castellians and all other national minorities. And moreover, as clearly demonstrated in Exhibit 1, Mr. Gravius had no intention to harm civilians. Therefore, the targeted group constituted of members of SNF and other people affiliated with SNF. Therefore, the targeted group was polarical in nature. And as it is widely acknowledged, polarical groups cannot come under the notion of protected group for the purposes of crime of genocide under Article 6. Thus, one of the main elements of the crime of genocide, namely the existence of a protected group, is not satisfied. And even if this court were to consider Castellians as a part of protected group, Mr. Gravius did not possess requisite dolus specialis. Madam President, Your Honors, if there are no further questions, I would like to thank you for your attention and give the floor to my co-counsel.
I'll just ask one follow-up question.
Yes, Madam President.
The prosecution in this case has specified that in their submission, it is Mr. Gravius who needs to have the special intent for genocide. Should this chamber decide that it is the physical perpetrators, do you have any defense or any response to that?
Yes, Madam President, we have response to that. And for the interest of time, I would like to ask your permission for my co-counsel to answer your question in his part of the submission, if it would not be a problem. Yes.
That's fine. Please proceed. Thank you.
Thank you very much.
Madam President, honorable members of the court, esteemed colleagues, good day. My name is Elizabeth Kakapadze, and may it please the court, I will be acting on behalf of the defense on this matter. Within the following 12 minutes, I will be addressing the second part of within the following 10 minutes, my apologies for the ambiguity, I will be addressing the second part of the second issue and the third issue. Firstly, I will prove in response to the prosecution's allegations that Mr. Gravius did not possess the requisite dolus specialis. Then I will move to the third issue, showing that Mr. Gravius is not criminally responsible for the crime of genocide under Article 28, paragraph A. Given the cumulative nature of the article, with your permission, the defense will solely focus on the mens rea element. Starting with and show that Mr. Gravius neither knew nor should have known that SPG, in coordination with NDS, were committing or about to commit the crime of genocide. Starting with the special intent, to answer the question addressed by Your Honor, I would like to refer your attention to the Stitch case, namely paragraph 133, where the court has interpreted that, and if I may quote, the fact that General Stitch had knowledge on his part alone cannot support an inference of genocidal intent. The special intent required for genocide necessitates each individual perpetrator, whether leader or foot soldier, having the intention to destroy the group or part of it when committing any of the prohibited acts. Therefore, it is our position that Mr. Gravis and the foot soldiers, all of them should have the special intent for the crime of genocide. As an initial point, it should be noted that the special intent requirement is an additional subjective element to the general requirement of intent and knowledge stipulated in Article 30 of the Rome Statute. And Mr. Gravis, following his declared counterterrorism campaign, never intended to destroy the protected group of Castilians in whole or in part as such. And the defense submits this based on 5 grounds. First, the selectivity in the killings indicates that considerations other than genocidal intent determine the scope of the victimhood. As stated in Al-Bashir case, in paragraph 138, the threshold for the mental state of the perpetrator is higher than a mere discriminatory intent. And if I may quote, the act listed in Article 2 of the Genocide Convention must be done with intent to destroy the group as such, in whole or in part. And the as such element, as correctly mentioned by the prosecution, means that the victims are singled out not by their individual identity, but because of their membership of a protected group. However, what prosecution has failed to show is that there is evidence that Mr. Gravis intended, as on the grounds of membership of a certain protected group, to target the Castilians. And the prosecution has relied on paragraph 13 of the case, namely Mr. X's statements. However, it should be noted that this court has decided in Gbagbo case that proving allegations solely through anonymous hearsay cannot be used by the prosecution as relevant evidence, because it puts the defense in a difficult situation, preventing from the exercise of the right to challenge the trustworthiness of the statements and to conduct its own investigations. Therefore, it violates the rights of the defense under Article 61, paragraph 6, subparagraph B of the Rome Statute. And Your Honors, let me draw your attention to the fact that Mr. Gravis intended to restore peace and security in the Republic of Huntington. Therefore, Mr. Gravis commanded to attack solely to CNF terrorists and their affiliated supporters. Your Honor, CNF consisted of all national minorities other than not solely Castilian ethnicity. Therefore, the violence did not specifically target the people of Castilian ethnicity. As for the second argument, contrary to what the prosecution has argued, the relevant indicator of the absence of the dual speciality is that the number of the village of the alleged victims in relation to the overall size of the entire Castilla was too insignificant to be considered as a partial destruction of a group. And as it has been stated in Al-Bashir case in paragraph 124, the genocide solely exists when the threat of the destruction of the group is concrete and real, not latent and hypothetical. Your Honors, the population of Republic of Huntington consists of 43 million. And the alleged acts were committed in the most densely populated cities of Luz and Lugari. However, the total number of the alleged victims—
Sorry.
Yes, Your Honor.
Looking at Exhibit 1, the message exchanged between Mr. Gravis and Mr. Joly, you don't think that Mr. Gravis has a president and commander was supposed to have a certain control on his troops and on the operations he ordered. But how was he monitoring and controlling the situation on the fact? Looking at Exhibit 1, do you think it's enough, it's sufficient, simple message exchanges for him to, to oversee the situation as commander? Is it enough for him? You don't think he should have taken additional measures to control the situation apart from message exchanges?
Your Honor, could you clarify the question? There is some background noise I couldn't hear. I apologize.
My point is, Mr. Gravus, as commander and president, was supposed to have a certain control on his troops and operations he ordered, right? But we can see that in Exhibit 1, he's only having exchanges, message exchanges with Mr. Jody, saying, can you report to me? You don't think that this is few and not sufficient for him as commander to control the situation? He knows that the situation was a little bit serious. You don't think he should have taken additional measures to control by himself in order to prevent him to engage his own responsibility in this matter?
Thank you, Your Honor, for giving the opportunity to clarify. In this situation, the relevant context is very important to understand. As it is known from the case facts, Mr. Gravus is struggling with the security situation and economic situation, which was caused by Castilian leaders who were immersed in corruption. And besides that, it is clearly shown that the government has been decentralized into 3 branches. Therefore, Mr. Gravus couldn't exercise effective control, showing, if I may tie with the third issue, and showing that there has been no knowledge on his part and obligation to take any measures, as he couldn't exercise effective control. He could solely, given the surrounding circumstances, exercise general control, which is not sufficient. And Mr. Gravus could rely on his entrusted subordinate, Ms. Jolie, and he did all measures to seek out the information. And if we also take into account the geographical distance of Hansen, of where Mr. Gravus is located, and Castiria, it is evident that Mr. Gravus did everything within his material power. And as I see, I'm running out of time. If I may ask 1 additional minute to briefly summarize my arguments regarding the third issue.
Yes, you can have 1 more minute. Thank you.
Thank you, Your Honor. As for the third submission, the defense argues that Mr. Gravus neither knew nor should have known that NDS, in coordination with SPG, were about to commit or committing the crime of genocide. Your Honors, as it has been stated in Bemba case, the knowledge on the part of the commander cannot be presumed, it should be proven, and the prosecutor failed to prove that Mr. Gravus had actual knowledge or had the obligation failed to fulfill the obligation to seek out the information, which is the should have known standard under the Rome Statute. Therefore, we ask this tribunal to find that the case is not admissible before the court. The case doesn't fall within the jurisdiction of the court, and Mr. Gravus is not criminally responsible under Article 28. Thank you for your attention.
Thank you very much. I'll give the prosecution 5 minutes for their rebuttal.
Right. Thank you, Your Honors. So on the admissibility, the defense challenged the admissibility, arguing that the same conduct and same individual test is met. But the case facts themselves show that the military court investigation is much broader than the necessary standard of a sufficient degree of specificity held in the prosecutor versus Gaddafi, that it was the case presented by the prosecution in this by the defense in this matter. The national investigations should prove with probative value, evidence, and sufficient degree of specificity that the conduct and persons are the same as the one of the ICC, being established on Gaddafi case that is not appropriate the court to simply expect that. Also, the defense is saying that the number of deaths are not sufficient to hold this case grave enough. The crime of genocide does not provide for a minimal number of deaths, but rather a general context in which these deaths and prosecution occur. The prosecution of a specific group for its nationality, ethnicity, race, or religion. In our case, the prosecution of Syrians, a minority, and a protected group were targeted. For example, the Black War in...
Sorry, I'll let you finish that point, and then I'll just have a question about one of your arguments.
For example, the Black War in 1820 was a war between British settlers against Aboriginal Australian in Tasmania, and it's considered genocide by historians with an average of 400 deaths recorded. Furthermore, the elements of crime of genocide must be present: a specific intent, destruction in whole or in part, and underlying acts. All those have been proven by the prosecution. Also, quantitatively, a considerable number of victims, taken into account the proportion of Syrian population, were killed and many more injured. And along with this, the excessive use of power by the security forces can also be established. If you want to ask your question now, Your Honor.
Yes, this goes back to your first point regarding an insufficient degree of specificity in the state's investigations. What is your response to the defense argument that the standard is actually lower for an individual bringing this challenge rather than a state? And they relied on the Gaddafi case, which you've also relied on.
There is a lower threshold for the defense to prove that, but as I said, the national investigation should prove with probative value the evidence a sufficient degree of specificity that the conduct and person are the same of the one of the ICC, and the court should not expect it that the investigations of the military court are ended for it to be established. So we need to establish now if the conduct is the same. So it's not the same. Also, on the argument of having actual knowledge, the defense mentioned they should have known standard. And if the court does not find the mens rea of actual knowledge criteria to be established, Mr. Graves should still have known that the subordinates were committing or about to commit the crime. The should have known standard requires a superior to have been negligent in failing to acquire knowledge of his subordinates' illegal conduct, as this court defined in Bemba case. It was the chamber's view that the should have known standard requires more active duty on the part of the superior to take the necessary measures to secure knowledge of the conduct of his troops and to inquire, regardless of the availability of information at the time of the commission of crimes. Also, it was held in the IC2I Blasty case in the trial chamber that ignorance of the commission of crimes cannot be a defense where the lack of knowledge results from negligence in the performance of his duties. Mr. Graves was negligent when performing his duties, since he did not inquire the heads of the three security forces, not taking the indispensable steps to guarantee that he was aware of the veracity of the situation. And for these reasons, the prosecution submits that the factors indicating they should have known standard are also met. Thank you, Your Honors. I finished my rebuttal.
Thank you very much. And we'll have 5 minutes for the defense to provide any rebuttal.
Thank you, Madam President. The defense would like to respond and mirror the structure represented by the OTP and raise the following 4 points. Firstly, I would like to clear the ambiguity regarding the standard of proof. The defense submitted that the standard of proof for the defense is lower than the one for the prosecution, not for the state. The standard of proof for the person challenging the admissibility and the state challenging the admissibility is the same. However, it is much lower than the standard of proof for the prosecution, which is the substantial grounds to believe and which, once again, has not been met by the OTP. And in this regard, it also should be noted that the specificity required by the standards expected from the defense has been met in the present case, since the same person and substantial the same conduct test has been satisfied. To move to the second part of our rebuttal, the OTP argued that the case was grave enough. However, according to clarification questions, the province of Castelia is populated by both ethnic Castilians and all other minorities. Therefore, attack against general population is not genocide. And since the whole province of Castelia was attacked and severe famine was devastating for the whole province of Castelia, it cannot be deduced that target of anti-terrorism campaign was ethnical group. It was general population of the province of Castelia, and the other 2 points will be addressed by co-counsel, if it may please the court.
Thank you, counsel. I will address 2 points, the number of the victims and the should have known standard. Starting with the first point, in response to what prosecution has argued, it is important to show that the numbers were significant enough to be regarded as partial destruction of the protected group. However, the prosecution failed to show that the numbers at given case, which is not more than 300 as mentioned, but 286 killings, amount to the substantial part of the Castilians. Therefore, they failed to show that the threat based on the number of the victims is concrete and real, as it is as these requirements are set by this very court. As for the should have known standard, the prosecution argued that due to the availability of information in general, Mr. Gravis should have known that the acts that the alleged acts were committed or about to commit. However, this very court has noted in Bamba case and in the paragraph 193 that it is the accused person's knowledge that matters, not the general knowledge. And the general knowledge cannot be imputed to the accused by the sole fact that there has been public information. And as for the negligence standard, Mr. Gravis did all within his material power, and he sought out information from Ms. Jolie, who was his entrusted subordinate. This concludes this rebuttal. Thank you for your attention.
Thank you very much for your submissions. If my colleague on the bench has no further questions, we will retire for deliberation. First of all, I'd like to thank everyone for your submissions, which were excellent across the board and really made for an exceptionally difficult decision for the bench. In fact, the most difficult decision, I think, of the moot court, at least for me thus far. In the end, we have decided to give the verdict in favor of the defense. But again, excellent submissions all around. The best speaker we would award to the first prosecution speaker, Ms. Rebuttal, and second best speaker we would award to the first defense speaker, Ms. Gigenti. So again, thank you very much and congratulations to all of you for all of your hard work and your truly excellent submissions.
Thank you, Madam President. Thank you, the other team.
Thank you very much.
Thank you for the feedback and congratulations to team 28.
Thank you.
The International Criminal Court is now adjourned.